Super. Thank you very much and welcome to our session. We're happy to be here. My name is Thomas Linder. I'm a tax partner at MME and my colleague Andreas Glarner is a legal partner, and that's why we try to cover both topics, regulatory and tax, with regard to digital assets. MME is a firm in the heart of Crypto Valley, so we have offices in Zug and in Zurich, and we're around 130 people there, but we are not only doing fintech, so we are certainly an advisory firm in a lot of different topics, but around 25 lawyers, tax experts, compliance experts of our team are predominantly working with DLT-based projects and are doing nothing else than trying to solve regulatory and tax issues. And 10 years ago, we had the privilege to support the Ethereum Foundation with the establishment of the foundation in Switzerland and with organizing the Ether pre-sale. And it really feels like centuries, so 10 years went by very fast on one hand, but a lot of different things happened in the meantime. And while supporting banks, exchanges, and financial intermediaries with implementation of digital assets in their services and in their infrastructure, we had to deal with a lot of regulatory and tax questions. And our learning, actually, just in general, is you need to understand the technology, just up front, need to understand the technology, and then you can try to understand the legal, the tax, the compliance consequences and implement a clear framework to manage the risks. But the most important learning is you need to work with brilliant people, and that's why now I hand over to Andreas to give you an introduction to our risk framework for digital assets.
Okay. Good morning. Does that work? Yes, it does. Good morning also on my end. Glad to be here in Geneva. So when we talk about this digital risk frameworks for digital assets, what are we actually talking about? And who is that addressed to? Mainly it is addressed to any kind of secondary market participants, but we have been using this framework a lot for banks and other similarly regulated clients of ours, which need to be in a position that they know what kind of assets are they actually dealing with. And this not only from a pure kind of regulatory perspective, so is it a payment token, is it an asset, a security token, is it a utility token, but also from a more risk-based approach, what kind of risk do I bring into my house, into my bank, for example, if I start providing custody services, trading services, staking services related to a particular assets, and what kind of VAT consequences do I face? So what we came up with, and the first version has been created already, I think back in 2017, I believe it was, the then called BCP risk framework that we have published. Is an open source document, version 2, which has been released in 2019, is currently on our website available, so you can visit that anytime. And we are currently working on version 3, together with Sygnum Bank, so the next release will be a joint release of Sygnum and MME in updating that framework. But what we want to do today is guide you through the principles of the framework. The framework itself constitutes of two elements. One is the concept. That's what we're going to look at in the next 30 minutes, roughly 35 minutes. And the other piece is really a large, very heavy Excel file, which then you, as a bank, a risk officer of a bank, or someone being responsible for the digital asset risk framework adoption, would then fill out for each particular token. We can't display that on a screen, it's simply too large. There are loads of questions, so we focus on the concept in this limited time we have today. And we look at the concept here, the overview. What does it consist of? It essentially consists of 4 elements. Key element 1 is token functionality. and then we look based on the understanding of the token functionality on the different tokens impact on the regulatory level, on the tax level, particularly VAT, and on the risk assessment level. I think that's also the way we want to kind of go through today with you, that you understand how this framework is built up on. And the first exercise we do, token functionality, essentially is nothing else than what lawyers typically do when they move into a new matter, that they look at trying to understand what is everything about. What is the functionality? What is actually the facts related to that particular asset? Is it a counterparty right? Is it a native token? What kind of layer is it operated on? What kind of more objective features does it have? And I need to understand all of these features to be able to assess then the regulatory consequences, the tax consequences, and also the risk consequences. So this is normally the exercise we start doing, and that we would advise that also the exercise everybody else would be start to do. And then once you have that, and I think it doesn't, looking at the limited time we have today, it doesn't make sense to discuss too much on the facts because it's different for each token. We move right into the different risk assessment. And the first one would be the regulatory token qualification. Can you move one slide forward? And when we look at regulatory token qualifications, we have basically, us being here in Switzerland and many of our clients also being in Switzerland and being subject to Swiss law. Of course, the Swiss perspective is the most important one to look at. But next to that, there are other cross-border considerations that need to be made, which we're not going to dive into too much today, but depending on the market you target as a service provider out of Switzerland, for example, you may be subject to MiCA, so you need to understand what are the MiCA rules applicable for particular digital assets. You may be targeting other markets, possibly the US market, so the SEC kind of practice comes into play. So all of these considerations need to be made on top. If we only look at the Swiss considerations to be made, you can move on. We all know, I presume most of us know the FINMA ICO guidelines. And just to recap on that a bit, these guidelines have been released in, I think, February 2018 that was. So just shortly after the big ICO hype ended, that started 16, 17. So it was not the guidelines who ended the ICO hype, but simply the bear market. But what was FINMA's kind of motivation to release that? So FINMA basically kind of watched the market. Always, it was clear they did have some rightfully had some legal concerns related to certain market participants, and those concerns related mainly to two elements. One was AML regulations, and the other one was kind of financial product regulations, security regulations. And so they came up with this model of 3 tokens, 1 token not being regulated, 1 being subject to AML regulations, and 1 being subject to security regulations. So if we go through that as a recap, we have utility token that represents some kind of a infrastructural access to a decentralized technology. A typical example would be ETH on Ethereum. So you need ETH to interact with the Ethereum protocol in the form of gas. You need ETH to be able to operate the node, so you can stake that. Classical utility functions. Then we have payment token, as the term says. Payment tokens serve as a mean of payment. Examples here will be Bitcoin, classical digital asset for payments, but also ETH, another example. And why ETH? You may ask, because I already said ETH was a utility. Yes, indeed. But ETH is a great example to demonstrate 2 things. ETH, at some point in time, started to be used quite widely, in a way, as a means of payment. So I don't really know when that was, but at that time, the qualification switched to a hybrid qualification. So ETH is now considered to be both a payment and a utility token. And that demonstrates basically that you can't only do your exercise once in the terms of qualification, you need to redo it once in a while because token qualification can change over time. And the third category are asset tokens, so token that represent some kind of a revenue stream, some form of a counterparty right, a right to a dividend or similar, which then are being treated as securities under Swiss law. There are also some further tokens, for example, non-functional utility tokens. So if you say, I'm releasing a utility token, but the utility will be implemented at a later stage, so after I have built my stuff, but the token is already out there, until the functionality is there, the token is treated as a security. An additional example where a token could be a security is when you say, I have a pure governance token, like a DAO token, DAO governance style, and my token controls on-chain the governance of a treasury. So if, in theory, the governance participants could jointly decide to pay out the treasury to themselves, then this indirect monetary benefit that you can allocate through the governance to yourself would also qualify as a security. So just to kind of give you a bit of an overview on these types of regulatory consequences when you look at a token, when you do that as part of the digital asset risk framework. And now, if you're a bank and you kind of do this exercise on a regulatory level, when do you do that? Obviously, before you start dealing with that token, that's clear. But can you only do it once? Not really. As I said, the token qualification can change over time, as we've seen in the example with Ethereum, with ETH. So you need to redo that once in a while. How often? That depends a bit on the risk framework of the token, of the total risk score a particular asset has, and on your risk appetite as an institution, but that's definitely like the key takeaway. You can't only do that once, and you need to do that on a regular basis. And how do you actually do that? Can you simply rely on a memo a client provides, like a MME Legal opinion, which is of course very valuable? No, but that isn't, and even a FINMA ruling, is that sufficient? My response would be no. You need to have your own assessment. Of course, it's very helpful to have a legal opinion. It's very helpful, even more, to have a FINMA non-action letter or ruling confirming certain regulatory status of a token. But all those opinions that kind of, they're only valid at the time they were issued. So you need to redo the exercise, and we would advise that you have a certain kind of automated system internally where you can ask some questions on the facts, and then it spills out the results, say, hey, high likelihood of utility, high likelihood of payment token, and you work with that. And what you do, I said at the beginning, we have this very large Excel file that you kind of fill in all the information, and then it prints out their score. And this is just for you, kind of, so you can imagine how that could possibly look like. You have a couple of questions related to the token, then you can answer these and you come out with a result. Here, Ethereum, hybrid token, utility payment, as we said before. So important key takeaways on the regulatory qualification element, and then I hand it over to VAT, which is a bit more complex than the regulatory side. Know your token, so really kind of understand the functionalities of a particular assets, qualify it before you start activities, and re-qualify or check the qualification you have done on a regular basis. Thomas.
Excellent. So now you've done this analysis, everyone is happy, you checked all the boxes, okay, maybe I need to fulfill AML, but I'm out of securities law, so let's go to market. And then hopefully someone says, but let's have a short look at taxes as well, just to be sure that we don't run into any risk. Why taxes? It's just relevant from a financial perspective. And I think if you do it wrong, it can kill your business. So, and the special focus is on VAT, because VAT is on your turnover, so it's a turnover tax, and it really can eat up all your margin, and if you set it up in an inefficient way. Maybe just a short refresher for the ones that are not VAT or tax advisors, and they don't have all the details. That's the Swiss VAT system, so it looks quite complicated, and it is. So there are 3 different rates. The ordinary rate is 8.1%, usually applicable to services, but there are also special rates and reduced rates for very specific services. Then you have 4 different treatments of transactions. So you have taxable transactions that are subject to VAT. You have exempt transactions that are potentially subject to VAT, but because it's, as an example, an export, it's then exempt under the law. Then you have exempt transactions like financial services, where you're not subject to VAT, but on the other hand, you have a disadvantage that you cannot credit any VAT that is charged to you. That is the exemption without credit. And then there are out-of-scope transactions that are not subject to VAT at all, like dividends or donations as an example, because there you don't have a supply of services or a supply of goods. And which transactions are subject to VAT? I already said it. It's the supply of goods and supply of services. And the definition there is that the supply of goods is granting the ability to economically dispose of an object in its own name. So if I sell you this microphone, that is a supply of goods, and if you pay something for it, then it would be subject to VAT. And then the supply of services is actually every supply that is not the supply of goods. So it's a Auffangtatbestand, so it's a kind of a negative definition. So everything you do and someone pays you for it might substantially or might be a service, qualified as a service. So that's IP, that there's licensing of rights, that is actually, if you promise not to do something and someone pays you, that's also a service. So it's a very broad definition, and certainly also tokens can be services. And the question is, if you issue tokens, if you trade with tokens, it's always the question, is it kind of out of this supply of service definition, or is it in? Because if it's in, then potentially 8.1% must be charged if you sell it to Swiss recipients. And as said, the margin maybe is gone if you need to charge 8.1, or the business is killed because no one wants to buy if they need to pay 8.1% in addition. So that was the short refresher on the VAT system. Now, if we look at tokens, there are also publications by the federal tax authorities about token qualification, about the VAT treatment. And we see here the same categories: utility token, payment token, asset token. So everyone is kind of relaxed and say, now FINMA said it's a utility, so I know how to treat it from a VAT perspective. Not true. So we have the same titles or categories, but different definitions. Because again, VAT doesn't care whether it's subject to AML or whether it's subject to securities law. They care whether it's a supply of service or not. And if yes, to whom you render it, and what is the remuneration for it, and what is the location of the recipient. So totally different viewpoint. So we need to do the same analysis again from a tax point of view. So we have here on the left side, we have also these 3 categories: payment token, utility token, asset token. Payment token as such are out of scope of VAT. So means of payment, if I sell you a means of payment, it's no service implemented in the means of payment, right? So it's just an exchange. Exchange of means of payment is out of scope. Then utility tokens, under the definition of VAT authorities, are a supply of services. So they are either taxable or exempt because these are financial services that are rendered. So this category is in theory taxable. And then you have the asset tokens. These are really the securities that are per definition exempt supplies. But there you need to be careful. They might not be subject to VAT, but we have stamp duties in Switzerland, we have withholding tax in Switzerland. So withholding tax applies to interest and dividends, stamp duty applies to contributions into equity or trading of securities. So these tokens might be subject to other turnover taxes, maybe not VAT, but maybe stamp duty. So I think where you see there then the FINMA categories, I think where we have the same kind of qualification is certainly if it's really a means of payment. So then it's from a FINMA perspective subject to AML, and then from a VAT perspective is no supply, so we don't have VAT on such transactions. On the other hand, I think also for the securities, so if you have a share, a bond, a fund share that is tokenized, or certain contractual rewards, we would treat it from a regulatory perspective as a security. And the same from a VAT perspective, where we then have potentially withholding tax or stamp duty issues. But everything in between, kind of these utility tokens, might be everything from a VAT perspective. So you said Ether as a native token was a utility changed into a payment token. Now from a mere VAT perspective, we would ask, is there really a defined service implemented in an Ether? So yes, I can access, but it's not a defined service from a defined counterparty in a defined location. So a lot of the requirements from a definition point of view fall out. So this utility would not be a utility from a VAT perspective. It would stay a payment token. The same for vouchers of values. So if you have a voucher for 10 francs to go to Migros to buy something, that's not, if you sell the voucher, it's not yet a service because you don't know yet for what you will redeem it. So what will really be the underlying supply? It's just a voucher of value. They're treated the same as payment tokens. However, as soon as it's a voucher of supply, where actually in the voucher or in the token it's already defined, I will get 1 hour of tax advice from Thomas Linder, resident in Zurich, then selling this voucher is already a taxable service. It's a prepayment of service. So small differences can have big consequences. Certainly the same if you have taxable supply of goods, of services, rights implemented. And as said, you need to still do then the distinction, is it really taxable or are we in the exempt area, like financial services, real estate, and some other transactions.
Yeah. And so, if I may add on that, Thomas, I think I mentioned at the beginning, the framework is designed for financial institutions. Yes, it is as a whole, but this question on are we moving in the field of a regulatory utility and are we tax exempt on the VAT level, yes or no, that goes far beyond financial institutions. And we kind of need to do this exercise very often when we support clients who have want to operate a very scalable application-based solution related to digital assets, which digital assets may be traded in a centralized way, but you don't want to have a necessity to identify users, because you can't, because it's fully Web3 based, because you want to keep it open, because it's designed for entertainment purposes, or you don't want to have people forcing into kind of a self-hosted wallet solutions, because you then can address a different market segment, which non-crypto savvy users. So there you need to remain in this utility token surroundings from a regulatory level, but of course also from a VAT level, because it otherwise could kill your business model. So this part goes far beyond financial services and financial institution. It really applies to the whole market as such.
And it's very important that already when you kind of define the token functionality, that you think about these aspects, because Andreas always tries to squeeze everything in this utility token category, right? It's unregulated, so woohoo! So let's go for it. But then I try to get away from the utility and qualify it as a native token, as a voucher of value, that we are rather in this payment token category in the green part there from a VAT perspective. And this combination is kind of usual. So all the layer 1 tokens have some utility from a regulatory point of view, but are treated as payment tokens from a VAT perspective. Now, just what does this mean? So if we have here a bank, we have a broker here in Switzerland, that is just exchanging tokens, buying, selling, buying, selling. You have on one hand, you buy from brokers or private people in Switzerland, or you have foreign suppliers, and then on the other hand, you sell to your customers in Switzerland, outside of Switzerland, or through some brokers. Now, if the token qualification is a payment or asset token, just in general, your activity will not be subject to VAT. So neither the input, so the purchase, nor the sale will be subject to VAT, and that's just normal kind of, that's what you know as a bank and as a broker. You have financial services, they are exempt, you don't really care about the tax treatment. However, as soon as you change it and you have a utility token, then the token might be subject to VAT. So either if you buy it from a broker in Switzerland, he would need to charge you 8.1% on the purchase price. Or, and that's also important, if you import it from outside of Switzerland, so you acquire tokens from a foreign broker, from a foreign individual, you are subject to an 8.1% acquisition tax. So you already have a tax liability on your purchases, and then if you sell it, again, if you sell it to Swiss parties, you would need to charge 8.1. If you sell it to foreign parties, that would then be an exempt transaction because it's outside of Switzerland. But here, in a worst case, you have 8.1% charges on your turnover, and in a worst case, you don't have a very limited credit opportunity on the input side. So this is really not where you want to be. And we had some cases, layer 1 tokens. As I just said before, usually they're qualified as payment tokens. So we are here, you can list it, you can sell it to customers, no one cares. However, then suddenly some project filed a ruling with the federal tax authorities, and the token was then qualified as a utility. And that immediately destroys the business case of the bank to list the token, and might harm the project then also in its approach to the market and the liquidity in the market. So that's a very important discussion, and especially secondary market can be hit quite hard with such.
And you may need to pay back VAT for the past 5 years, which can become very painful.
Yes, on the total turnover that you've made so far, even if you didn't make any profit, right? So it's not the profit tax. So you can make losses, but you pay VAT. And then here, certainly we do the same as our colleagues in the regulatory part. We ask the questions, so is it a link to ownership of an underlying object? Is a service linked with the token? Do you have rewards, etc.? And out of these questions, we come then to a certain qualification. Also here, you can ask the federal tax authorities for their opinion. The risk is always that you don't like their opinion, but certainly gives you some legal certainty. And the knowledge on the authority side is already quite high, and they generally know what they're doing. With one caveat out of practice, it really depends to whom you're talking in the federal tax authorities. And funnily, the ones that have been kind of exposed to the topic have been certainly the German-speaking people in the authorities, because Zug was kind of the first location where these topics came up. So we have some projects in the French-speaking part that file rulings with the authorities and they get different answers than if I file it in German, in the German-speaking part. And so we can also leverage on that and kind of use it from a strategic point of view, but just you need to be careful and you need to be really watching who is kind of providing you with this opinion. And if you don't like the outcome, we can also try in another language.
Yeah, and maybe, as you remember, we had this kind of 4 parts, the factual kind of understanding of the digital assets, and the regulatory assessment, the tax assessment, which is important not only for the financial institutions, but basically for everybody who kind of somehow has a certain activity related to assets. The risk assessment part, like the last part, is focused more kind of a, you know, suitability test, like MiFID requirement adoption, but for digital assets. So kind of understanding factual and technical and contractual risk related to certain digital assets. In the framework that has been published now, which you can, as I said, download from our webpage, there are roughly 60 different categories and subcategories that you can move through as a risk officer to understand particular assets. As I said, we're going to publish very soon, I think, beginning Q1, the new version of that together with Signum. But so just for you, a rough understanding. No, the last one. No, the risks. What kind of risk are we looking at? It is, the technology-related risk. Do we really have sufficient decentralization and a node level? What is the adoption of a certain protocol, for example? How long has it been in the market? When was it deployed? How many users does it have, etc. Then a certain counterparty risk. There may be proper counterparties in terms of contractual, particularly related to asset token, but in a more decentralized way. Do we have dependencies on particular individuals, on particular companies? Is it really decentralized? We talk about DeFi setups, for example. Do we understand that? What kind of market risks do we face? And do we have any kind of sanction, AML-related policy risks? So if you say, okay, we have some kind of a staking model, for example, you need to understand where the staking revenue come from. Are they freshly minted token? Then obviously we have a very low risk. Are these tokens which come from a certain kind of a liquidity pool or from third parties feeding into a pool? Then we have another risk framework to understand. So these are the questions that we ask, and then you come with a risk score from it's A to E. In this version, it could be 1 to whatever, but basically understanding is that something of high risk, of low risk, depending on the risk factors and the risk weighting.
We need to wrap up because time is up.
But the good thing is the key takeaways we've already covered a couple of times. So what are these? Just to wrap up again. First thing, know your token. Understand before you do any activities related to a digital assets, what is this digital assets on a functionality, technical perspective, and then based on that knowledge derive what kind of legal regulatory qualification does it have, what kind of a VAT tax treatment comes along with it, and what is the risk weight of a particular asset. And you need to build out a framework which kind of gives you a process how to assess that, and which also helps you to kind of keep in mind that you need to monitor those assets on a regular basis and redo the exercise once in a while. I think that's, from my end, the key takeaway. Anything to add, Thomas?
No, just don't forget about taxes. And we're still around. Certainly today, just ask us a question if you're interested. And thank you.
Thanks a lot.